Let's begin with the Supreme Court because the Apex Court has, in a unanimous decision, dismissed an application filed by petitioner John Dramani Mahama seeking a review of an earlier ruling affirming the right of the chairperson of the Electoral Commission, Jean Mensah, not to testify in the ongoing case. Chief Justice Kwesi Ening-Yeboah, who read the ruling on behalf of the justices, said the bench was not convinced by the arguments advanced by the petitioners to warrant a contrary decision. This was after lawyers for the parties had advanced arguments in respect of their positions on the matter. My colleague Kwekwa Asante has more in the following report.
The Supreme Court has again, in a unanimous decision, dismissed a review application filed by lawyers for former President John Mahama, which sought to challenge the decision of the Apex Court not to compel the chairperson of the Electoral Commission, Jean Mensah, to testify in the ongoing election petition. The 9-member review panel held that they were not satisfied that new or important legal matters had been referenced to justify the petitioner's call for a review. According to lead counsel for the petitioner, the court should review the decision because the court failed to refer to sections in the Evidence Act of representations made by the EC chairperson in her earlier affidavits in court.
A trial judge would be within his rights, even under the Courts Act, to summon a witness. A trial judge would be within his rights to do that. But, my lords, we considered that the circumstances that were before you, based on their own conclusive presumption, made it appropriate at that point for there to be a ruling that she should testify and therefore be subject to cross-examination.
Both first and second respondents argued that the application did not meet the stipulated criteria in law for a review.
It's our submission that there has been no fundamental errors of law which have occasioned a miscarriage of justice or constitute exceptional circumstances to warrant this court reviewing its decision.
My lords, it is our respectful view that this application does not appropriately invoke the special review jurisdiction of the court.
Here is how the court ruled after hearing arguments from both legal teams of the petitioner and the respondents.
Counsel submitted that this court in the ruling and the review failed to consider. We have considered the submission on the effect of Section 26 of NRCD 323. We are not persuaded that the issue of statutory estoppel urged on us by the applicant's counsel by reason of not specifically referred to in the ruling and the review renders the ruling per incuriam. We have also taken into consideration the applicant's reliance on Article 19, Clause 13, and 296 of the 1992 Constitution. Yes. We are of the view that the applicant has failed to satisfy the court that new or important matter resulted from the reference to the constitutional provisions referred to. In the result, the application fails and it is hereby dismissed.
Lawyer for second respondent Akoto Ampao is calling on the court to award cost against the petitioner for abusing court processes.
Very well, however. But my lord, I think that the court should be amenable to grant costs even in constitutional matters.
Please, we won't.
When there's, I'm not talking about in this one, when there's a continuous abuse of process. I think that it should be possible.
On rumors that spokesperson for the petitioner, Dr. Dominic Aini, had been cited for contempt by the court, another spokesperson, Sami Jemfi, disclosed that no official court process had been served on Dr. Aini.
First of all, Dr. Aini is not in court today and is not with us here because he lost a friend and he had to go for the funeral. That is why lawyer Tony Leta is also not in court. So he's not in court, not because of any alleged contempt proceeding that has been brought against him. Number two, officially, we are also not aware of any contempt proceedings that has been brought against him. We've seen a publication by Asase Radio which makes reference to no process. And we don't know how they got that information. So we will wait and get confirmation of that before we can make our position on that known. But be rest assured that Dr. Ayine is a senior member of the bar. He will not deliberately disparage the court or seek to scandalize the court in any way. And he's capable of explaining these issues.
So just before the court would issue its orders for how the case would proceed, Mr. Chachuchi Kata raised some objections to its applications that are currently pending before the court. The court is scheduled to come back on Monday to hear another review application that has been filed by lawyers for Mr. Mahama, seeking to review the ruling of the court in its decision not to allow the petitioner to reopen its case and issue a subpoena against the chairperson of the Electoral Commission, Madam G. Mensah. Attached to that review is also a stay of proceedings so that the court order for all parties to file their respective closing addresses before the court sets a date and adjourns for judgment will be halted for now.